Imagine this for a second. Your life, maybe your job, your home, everything you've carefully put together suddenly becomes uncertain. Not because of anything you did, but because of, well, a single government decision.
Yeah, it's not just hypothetical. That's the kind of real-world impact we're actually diving into today.
Right.
We're looking at a pretty significant and recent Supreme Court decision.
Right, and at the core of it is something called an application for a stay, like a pause button the courts can hit, and a really, really powerful dissenting opinion from Justice Jackson.
Mm-hmm. And everything we're discussing, all the insights, they come straight from Justice Jackson's own words in her dissent. The case is Noam v. Doe, decided just back on May 30th, 2025.
It gives you a pretty stark look inside the disagreements that can happen even at the highest court.
Definitely. So our mission really is to unpack this, cut through some of the legal speak. We want to explore what a stay actually is in the Supreme Court context, what rules they're supposed to follow when deciding on one.
And crucially, how Justice Jackson argues those rules were, well, maybe misapplied or even ignored in a case that affects just a staggering number of people.
Almost 500,000, yeah. It's about understanding how these sometimes seemingly technical legal moves can have massive human consequences.
Okay, so let's start right there. This idea of a stay. What exactly is it when we talk about the Supreme Court and, why is it such a big deal?
So a stay really is, like you said, a pause button. Legally speaking, it temporarily stops a lower court's order from going into effect. This happens while an appeal is ongoing or while the higher court decides if it even wants to take the case.
So it buys time, basically.
Exactly. Justice Jackson, in her dissent, she puts it really clearly. She says the core problem stays are meant to solve is what to do when there is insufficient time to resolve the merits and irreparable harm may result from delay. It's meant to be a safety valve.
A safety valve.
There you go.
Okay, so it's designed to prevent harm while the legal process plays out.
That's the idea. Its purpose is to prevent irreparable injury. So, serious harm that can't be easily fixed later to the parties involved or even to the public while the case is still being decided.
But it sounds like in this particular case, Justice Jackson's argument is that the Supreme Court's action, granting the stay, might have actually caused harm instead of preventing it.
That is precisely the heart of her dissent. She argues the tool designed to minimize harm was used in a way that could unleash it. And, there's another layer here.
Oh.
When a court of appeals, like the First Circuit in this case, has already looked at the situation and decided not to grant a stay or not to interfere with the lower court's stay.
Which is what happened here, right? The First Circuit didn't disturb the district court's initial pause.
Exactly. In that situation, the party asking the Supreme Court for a stay, in this case, the government faces what the court itself calls an especially heavy burden. Getting a stay from the Supreme Court in these circumstances is supposed to be extraordinary, rare.
Okay, that's a really important context, and especially heavy burden. So with that in mind, let's get into the specifics of this case, Noam v. Doe. Who exactly was involved, and what was this program that caused the dispute?
All right, so on one side you have Kristi Noem, who is the Secretary of Homeland Security, DHS, and on the other side you have Svetlana Doe. That's a pseudonym representing a group of other non-citizens.
And the program?
It was called the CHNV program. CHNV standing for Cuba, Haiti, Nicaragua, and Venezuela. It essentially allowed almost 500,000 people from those countries to live and sometimes work legally in the U.S. for up to 2 years. They had a temporary status called parole.
And how did people get into this program? Was it automatic?
Oh, definitely not. It was discretionary, meaning the government chose to do it. And crucially, it involved a pretty rigorous, individualized application process for every single person. They were vetted.
Okay, so these aren't people who just showed up. They applied, were approved under the specific program, and were, building lives here. What happened to change all that?
Well, things shifted dramatically on January 20th, 2025. The president issued an executive order, number 14165, Section 7B, telling the DHS secretary to, quote, terminate all categorical parole programs.
All of them, not just CHNV.
The order said all categorical parole programs. Following that order, DHS then announced it was terminating the status of all the CHNV parolees, this group of nearly 500,000 people en masse. Like all at once.
How did they announce that?
Through a single notice published in the Federal Register. So not individual notices, not case-by-case reviews based on the original parole grants, just one blanket announcement.
Yeah.
Everyone's parole under this program is being cut short.
Wow. Okay, so how did the courts react when this was challenged?
Well, the non-citizens, Doe and the others, they sued. They argued this mass termination was legally speaking, arbitrary and capricious. Basically, that DHS didn't have a good legal reason and that it went beyond its authority by ending parole this way all at once instead of looking at individual cases.
At first court.
The district court in Massachusetts actually agreed with him, at least initially. It issued a temporary stay against DHS's termination notice. The judge found that the relevant federal law seems to require that parole terminations happen on a case-by-case basis.
So the district court basically said, hold on, you might have to do this individually, not all at once.
Pretty much. And then it went up to the First Circuit Court of Appeals. They reviewed the district court's temporary stay and decided not to disturb it. They didn't overturn the pause.
Okay, so the pause remained in place.
Yes, and interestingly, the First Circuit even invited the parties to submit briefs, quickly expedited briefing, so they could decide the actual merits of the case faster. Is this mass termination actually legal or not?
That sounds like a pretty standard, sensible path forward. Let's figure out the legality quickly.
You'd think so. But here's the twist. The government, DHS, instead of taking the First Circuit up on that offer for a faster decision,
They did something else.
they bypassed the First Circuit entirely on the stay issue and went straight to the Supreme Court, asking them for a stay of the district court's order.
So they skipped the expedited process in the appeals court and went for the emergency break at the very top.
Exactly. And that move, asking the Supreme Court for this extraordinary relief, especially after the First Circuit declined to interfere, is really what sets the stage for Justice Jackson's powerful dissent.
Which brings us right to it. Justice Jackson argues the Supreme Court didn't just disagree on the outcome, but that they fundamentally botched, as she put it, their own established rules for granting a stay. What are those rules?
Right. This is where the legal mechanics get critical. There's a standard four-factor test the court uses. It's been around a long time.
Okay, what are the four factors?
First, the applicant here, the government, has to show there's a fair prospect. The Supreme Court will eventually agree to hear the case on its merits, grant certiorari, and that there's a fair prospect they'll reverse the lower court's decision.
So a decent chance they'll win in the end. What's second?
Second, they need to show the merits of the case actually favor them, that the law is likely on their side.
Okay, likelihood of winning, merits favor them.
Third, and this is crucial, they absolutely must demonstrate that they will suffer irreparable harm if the stay is denied. Meaning, if the lower court's order stays in place while the case proceeds, they'll be harmed in a serious, unfixable way.
Irreparable harm. That sounds important.
It's more than important. Justice Jackson emphasizes this factor is indispensable. If the applicant doesn't show irreparable harm, the court shouldn't even need to look at the other factors like the merits. The inquiry should stop right there.
Got it. Indispensable. And the fourth factor?
The fourth factor, which usually comes into play if the other factors are close, is whether the balance of equities and the public interest favor granting the stay. Basically, weighing the potential harm to both sides and considering what's best for the public.
Okay, four factors, but irreparable harm is the gatekeeper. So where does Justice Jackson say the majority went wrong applying this test to the government's request in Noam v. Doe?
Her main point, her first and maybe biggest critique, is that the government completely failed to demonstrate that indispensable factor, irreparable harm.
What did the government argue was their harm?
DHS basically argued that the district court's order, the one stopping mass termination, prevented it from carrying out its duties related to immigration and foreign policy. Kind of a general argument about executive power.
And Justice Jackson didn't buy that.
Not at all. She countered that DHS didn't show any urgent need to terminate all these paroles right now before the courts could even rule on whether the termination itself was lawful. There was no specific immediate threat cited.
So no specific national security crisis or foreign policy emergency that required immediate mass termination.
Exactly. She points out they didn't identify any specific problem that would arise from simply letting the existing parole grants continue while the case went through the courts, especially since the First Circuit offered to speed things up.
And she mentioned something else too, right? About case-by-case termination.
Yes, a really critical detail. She highlighted that the district court's order didn't stop DHS from terminating CHNV parole entirely. It only stopped the en masse termination.
Yes.
DHS still had the power, under the district court's order, to terminate parole on a case-by-case basis if they had grounds according to the statute.
So they weren't completely powerless, they just couldn't do it all at once through that single notice.
Correct. And then she points to the fact that the government actively eschewed, that's the word she uses, basically means they deliberately avoided the First Circuit's invitation to get a quick decision on the merits.
Which kind of undermines the claim that this was super urgent, doesn't it, if you avoid a faster resolution?
That's her argument. How urgent can it be if you bypass the chance for a quicker final answer? So for Justice Jackson, this failure by the government to show any real, specific, irreparable harm should have been the end of it. Stay denied.
But obviously the court did grant the stay. So her dissent goes further. She doesn't just talk about the government's lack of harm, she really focuses on the harm to the other side, right? The parolees.
Absolutely. This is where the dissent becomes incredibly stark and focused on the human cost. She talks about the tangible, imminent, and significant harm that granting the stay would cause to the nearly 500,000 CHNV parolees.
What kind of harm are we talking about?
Granting the stay meant the district court's pause was lifted, allowing DHS's termination notice to immediately go into effect. It would, in her words, immediately effectuate the en masse truncation, the cutting short of all parole grants for approximately 500,000 current CHNV parole beneficiaries.
500,000 people, just immediately affected.
Yes, and she reminds the reader who these people are. Many fled violence, poverty, or political instability in Cuba, Haiti, Nicaragua, Venezuela. They came often at the express invitation of the U.S. government under this program.
They went through the process, got approved.
Right. Many have sponsors here. They've settled into communities, found jobs, enrolled kids in school, built connections. Many were hoping this parole was a stepping stone to more permanent legal status, maybe applying for asylum.
So pulling the rug out from under them like that?
She predicts social and economic chaos will ensue. You suddenly have this huge number of people whose legal status evaporates overnight. And she lays out what she calls two unbearable options facing them.
Unbearable options. What are they?
Option one, they could choose to leave the United States. But that likely means returning to the very dangers or instability they fled, potential separation from family members who might remain or who are U.S. citizens, and giving up any chance they had to pursue asylum or another legal remedy here.
That sounds awful. What's option two?
Option two, they could choose to remain in the U.S. after their parole is terminated, but then they'd likely be undocumented. They'd face the risk of imminent removal, possible arrest and detention by immigration authorities, losing their authorization to work legally, and losing pathways to adjust their status.
So either return to danger or live in the shadows here, facing deportation. That does sound unbearable.
And her point is that this harm, this tangible, devastating harm to 500,000 individuals and their families and communities, massively outweighs any generalized harm the government claimed it would suffer by simply waiting for the courts to decide the case properly.
She basically says granting the stay facilitates needless human suffering.
That's her direct quote. Needless human suffering allowed to happen before the fundamental legal question was even answered by the courts.
Now, to add more weight to her argument, Justice Jackson also brought up past cases, didn't she? She suggested the court wasn't being consistent with its own recent decisions on stays requested by the government.
Yes, that's another key part of her reasoning. She argues the court has repeatedly denied similar stay requests from federal agencies in recent years. She's essentially saying, we've seen this movie before, and we usually rule the other way.
Can you give us an example she used?
Sure. She pointed specifically to Biden v. Texas. That case involved the controversial Migrant Protection Protocols, or MPP, sometimes called the Remain in Mexico policy.
Right, I remember that.
And she also cited United States v. Texas, which was about DHS guidance on priorities for immigration enforcement. In both of those cases, the government went to the Supreme Court asking for a stay.
And what was their argument for harm in those cases?
Very similar to this case, actually. They argued that lower court injunctions were interfering with the executive branch's authority over immigration and foreign policy, causing them irreparable harm.
And what did the Supreme Court do in those cases?
They denied the government's request for stays. They refused to pause the lower court orders in those instances.
So Justice Jackson is pointing out a potential inconsistency. The government makes similar arguments about harm from interference, but sometimes the court denies the stay, and this time they granted it.
That's exactly her point. She suggests these past denials show the court isn't typically swayed by just a bald contention like an unsupported claim, that the government is irreparably harmed simply because its policy preferences are burdened by a court order.
Yet, in Noam v. Doe, she feels the court did accept that kind of general claim, even without specific evidence of urgency, and crucially, while seemingly overlooking the massive harm on the other side.
Right. She finds it puzzling how the court reached the conclusion it did in this case, given the precedents and the lack of demonstrated irreparable harm to the government compared to the very real harm facing the parolees.
So bringing it all together, what's Justice Jackson's final word on this? Her conclusion in the dissent, it sounds like she felt quite strongly about this decision.
Extremely strongly. She concludes by saying that when the stakes are this high, measured not just in legal principles, but in real harm to real people, you'd expect the government to come forward with a mountain of harm-related arguments bolstered by evidence.
And they didn't, in her view.
In her view, they fell far short. She then expresses, maybe with a bit of incredulity, that the court somehow decided the balance of equities favored the government. She finds it hard to understand the implication that it's somehow in the public's interest to have the lives of 500,000 migrants unravel all around us before the courts decide their legal claims.
That's a powerful framing, putting people's lives in turmoil before the legal questions are settled.
And her final sentences are incredibly direct. She says that even if, down the road, the courts ultimately decide the law does allow the government to terminate parole this way.
Which is still an open question at this stage.
Exactly. Even if that's the final outcome, she argues the court should have followed its standard procedures for stays. They should have demanded a real showing of irreparable harm, properly weighed the equities, and likely denied the stay, letting the courts decide the merits first with that necessary harm-centered focus.
But they didn't.
They didn't. And she concludes that by granting the stay without, in her view, proper justification, the court allowed the government to proceed, effectively rendering constraints of law irrelevant and unleashing devastation in the process.
Unleashing devastation. Those are incredibly strong words from a Supreme Court justice about her own court's action. It really highlights this tension, doesn't it, between the technical legal rules for something like a stay and the immediate, very human impact.
It absolutely does. Justice Jackson's dissent really throws that tension into sharp relief. It's a powerful example of how different members of the court can see the same facts, the same legal standards, and reach dramatically different conclusions about the consequences.
Yeah.
It reminds us these aren't just abstract legal debates.
Yeah. It really forces you to think about the real people affected by these decisions, sometimes instantly.
And it underscores the importance of dissent.
Yeah.
It provides that different perspective, it highlights potential problems or overlooked consequences, and it contributes to the ongoing conversation about the law and its application.
So, perhaps the question we leave you, the listener, with is this. How should our legal system balance these competing needs? The need for the government to act, to govern efficiently, versus the need to protect individuals, especially vulnerable ones, and prevent massive disruption while the courts are still figuring things out.
It's a fundamental question, really. What is the role of the courts, especially the highest court, in managing these situations? How much weight should be given to potential harm, even when the final legal outcome isn't clear yet? There are no easy answers.
Definitely something to think about. The balance between process, power, and people.